Hello everyone, welcome to today's video, which is designed to help recruitment agencies start to consider some of the system and process changes they'll need to make in time for the extended off-payroll rules going live in April 2021. Here are my top tips for how to approach these changes from someone who supported multiple agencies with implementing the rules, both for the public sector in 2017 and the private sector in 2021. Firstly, you need to identify what's different or new in how you set up placements once the new rules are live. One of the best ways to capture this changed or new requirement is to organise workshops with all of your front and back office functions. If you include representatives from every department, that'll make it less likely that something gets missed out or isn't considered. During the workshop, talk through all the possible scenarios and permutations that the new off-payroll rules bring, and decide how your current processes or technology need to be adapted to accommodate those requirements. We'll be covering some of the main considerations in a moment, just to help you get started. You should also schedule in at least 1 or 2 more workshops after the rules have gone live, once your new processes are being used in practice, just to make sure everything's working as it should. I always find it helpful to do dummy runs when, for whatever reason, you need to adapt or amend your current placement processes. So you use dummy candidate and client records to set up imaginary placements, but they're tracked through your current systems and processes as though they were real. And often that really helps to work out where the gaps are. Next, decide where in the placement process this different or new requirement needs to sit. For example, determining whether a client is exempt from applying the off-payroll rules needs to happen before any other aspect of the placement process begins. Once the rules have gone live, you need to know what the status of a role is as soon as it's released by the client, and preferably before you even agree the charge rate, because if a role is inside IR35, then you may want to increase the charge rate to cover off your additional statutory costs, or to ensure that the pay rate to the contractor is sufficiently high to attract quality candidates, despite the fact that the role is inside IR35. You also need to determine whether the new or amended requirement needs manual intervention or whether it can be done and via an automated option. Now, just a warning here, it's best not to automate too many tasks too early. What clients and contractors do in the run-up to the 6th of April 2021 may be very different to what they're doing 6 or even 12 months after go live. Any tasks that are the same, 80% or more of the time, they are the ones that are ripe for automation, and you manage the non-standard 20% manually as an exception. But if you don't yet know what types of tasks are going to be the same 80% of the time, well, you run the risk of automating the 20% exception rather than the 80% rule, meaning you have more manual tasks to carry out for each placement. Lastly, decide who will do the new or changed task or requirement. If it's a manual process, you'll need to allocate a person or team to be responsible for completing the tasks. If it's an automated process, well, which software or system will capture that requirement? Will it be your CRM, your applicant tracking system or ATS, your pay and bill software, or your accounting packages? You need to choose the right system to store data on, and make sure you train your staff so that they all know who's doing what in terms of manual tasks and what goes where in terms of system information and data. Because once you've decided on a particular system for storing or tracking particular information, you need to make sure that that location is used consistently and you don't have data being uploaded or inputted into the wrong system. So what are some of the system and process changes to consider? Well, firstly, let's look at contractors. Going forward, you'll need to check that all PSC contractors are indeed PSCs, by which I mean the individual worker performing the services should have an element of ownership or beneficial interest in the intermediary they are contracting through. So for a limited company, that means ensuring that the worker owns at least some of the shares in that limited company. Now, any amount of ownership is sufficient, even as little as 1%. If the intermediary is a partnership, though, well, the worker performing the services must be a partner of that partnership and must be entitled to more than 60% of the profits as well. Next, let's look at clients. And the first thing I'd consider is how to identify exempt clients. Not all clients are required to consider and apply the off-payroll rules. And whether the client is exempt, well, that impacts on all other aspects of the placement. So in terms of where this sits in your process, it's right at the start. So any current clients should be asked if they are exempt, and any future clients you engage with should also be asked as soon as possible. As to whether this is a manual or technology-based process, well, it's probably a combination of the two. And that in turn will dictate who will be doing it. Generally, it'll be a person, probably a recruitment consultant, asking the client if they're exempt. If you're going to require the client to give you a signed declaration or some similar document rather than just accepting verbal confirmation, then sending out the declaration template can be manual or automated. You will likely add a fixed reportable field in your applicant tracking system to be able to easily identify exempt clients, so that's tech-based. And then you need to consider how often you will ask the client to reconfirm its exempt status. My advice is that you ask the client before the beginning of every tax year, because if a client is exempt, it is always exempt for the full tax year. For clients who aren't exempt and therefore are affected by the off-payroll rules, so any public authority and any medium or large-sized private sector business, well, I'd want to track what tool or methodology they are using to make determinations, because that has an impact on you, and it's called the fee payer risk. Now, we have other content on the Navigator portal that talks in more detail about that, so I won't cover it here. But suffice to say, I'd want to understand the quality of the methodology that the client is using to assess status, because that might affect how risk averse or risk tolerant I am in relation to any assignments that are deemed outside IR35 by the client. I'd also strongly recommend that you review all your terms and conditions with your clients for any tax indemnities. Depending on how they're written, a tax indemnity in the client's favour could make you liable even where the client hasn't complied with its own obligations under the off-payroll rules. That in turn might make you deal with the client and any SDSs they give you slightly differently. And if that is the case, you need to make it as easy as possible for you to find and monitor that information. Now let's move on to specific placements or assignments. Now, obviously, all current and future PSC assignments will need to be tracked through the status assessment process, and you need to ensure that your client has given you an SDS for the assignment, preferably before it starts. Presumably, you'll want to store copies of the SDS on your applicant tracking system, so you need to decide where it goes and who's going to upload it. Clients are legally required to ensure the worker and the agency receives a copy of the SDS. But it's likely that in practice, the client will ask the agency to send it on to the worker rather than the client doing that themselves. So if that's the case, you need to have a defined, auditable process for sending SDSs onto any other parties. I'd also encourage you to consider whether you will ask your client for regular reviews of the SDS to ensure that the status is still valid. Now, it's not your responsibility as an agency to do that. The legal obligation is on the client to monitor any changes to assignments that might affect IR35 status. But I think many agencies will be tempted to send a gentle reminder, perhaps once every 6 or 12 months, just to request that the client reviews the SDS and takes account of any significant or material changes. Once you have the SDS, you need to make sure that you are set up for the right type of placement. So, for example, for roles that are deemed inside IR35, you might allow only umbrella or PAYE contractors to fill that role. So you need to have some kind of check in place that doesn't allow you to accidentally use a PSC contractor for that type of placement. You'll also need to be able to distinguish in your systems between PSC contractors and umbrella contractors. Now, some systems don't make that distinction. And if you don't have an automated method for differentiating PSCs and umbrella, by that I mean a specific reportable field in your applicant tracking system, then you do need to get that in place as soon as possible and track placements manually in the meantime. You'll also need to account for the fact that you might have 3 different types of PSC placements in the future, for which you might want to consider adding new fields into your applicant tracking system. PSCs working at an exempt client, for example, are different from PSCs working outside IR35 with a client that has determined status. And if you've decided to offer a deemed direct payment option, well, you'll also need to be able to identify PSC placements that are inside IR35. One of the reasons for ensuring you have all these distinctions is to make sure you're issuing the right types of contracts, both to your clients and to your contractors for the particular type of placement you're using. And we have a separate video on the Navigator portal all about contracts, so do be sure to check that out for more information. I do hope that this video has given you at least a starting point when looking at your system and process changes to accommodate the off-payroll rules. Thanks so much for watching.